That's the first obstacle overcome. Great. Okay, so this is, you heard who I am. I don't want to dwell too long on my own background, but I would just say that I've, as Lars has said, I've spent a good many years. Actually, I've always lived in China during that time when I was in Asia, although I've worked in various countries around Asia as well. And while I was out there, I for a while, I was chairing the IP committee at the American Chamber of Commerce and had the opportunity to meet with various judges and law enforcement people around China. So a wonderful experience and very interesting to talk, meet and chat with those people. So moving forward, this is the kind of agenda that I wanted to run through today. I'll tell you very briefly about the China Help Desk, because it's something that you can make use of, and it's free, and your tax money has already paid for it. So it's a great resource if you'd like to make use of it. And then talk about China and the current drive for innovation, which is so interconnected with new business and startups and indeed intellectual property. I thought it would be helpful just to draw a comparison between China and the EU, so you can kind of get a sense that there are differences between the two regimes. We'll inject a case study or two just to give a feel for how these things actually work, and cover a few points on intellectual property in what is an evolving economy. And I hope to leave you with some key tips to take away with you. This is obviously a pretty broad topic, so I'm not going to go into huge depth. My aim is really to try and incite issues in your mind so that you will think of these things in future when you come across them, and that will prompt you to perhaps work with people who are more expert in the field to help steer you on the right path. That's really the key aim today. So let me just explain who the China Help Desk are. Well, this is a European Commission funded initiative. I've actually been leading the China Help Desk since its inception, indeed since the concept phase more than a decade ago, and it's continued to run. It's been very successful. It's a practical support service for European SMEs interested in doing business in or with China. It's there to provide information and advice and help steer businesses in the right direction. The main reason behind it was that the EU or the European Commission recognized that when you're a startup or a small company, you don't have the resources or the knowledge to make sure that your new innovative concept and business idea will succeed and will flourish from an intellectual property rights perspective. So that understanding the need to nurture businesses at that stage, that was the whole impetus behind the China Help Desk. The China Help Desk covers these different areas. So China, Hong Kong, Macau, and Taiwan. They're listed separately because they all have different rules and laws. So something to be a little bit aware of. Don't assume what goes in China legally applies in Hong Kong or Taiwan or Macau. It's different. What does the China Help Desk actually do in the way of services? Well, there's the main service is the inquiry helpline. This is a resource where you can contact the help desk by phone or by email or via the website, and you can ask a question specific to your business. And the question will be handled confidentially, and you will get access to a team or panel of experts who will then provide you with personal advice on IP issues. So a tremendously useful resource. Do feel free to use it. Apart from that, well, there are obviously training workshops, obviously more internet-based these days, but hopefully in the coming months we will have some live events too and webinars. There are many guides and fact sheets published on the China Help Desk website as well, so well worth a visit there. You may indeed find some information that you are looking for on the website. And this is an example of the sorts of guides that you can freely access and freely download. They're in PDF format, and we'll go into some detail about specific issues in China, either on a business angle or from an IP perspective. So you can find guides on patents, or you can find guides, for example, on technology transfer to China, giving you a broader cross-section of what you need to know for that kind of topic. So that's the China Help Desk. We have, because of the success of the China Help Desk, it's kind of spawned other help desks. So you're now able to access help if your business goes into other jurisdictions as well. Similar projects, again, these are developed by and on behalf of the European Commission. So you've got a Southeast Asia IP help desk, an India help desk, which is the newest one, and a Latin America help desk. There's even a European IP help desk too, to support businesses in the EU. So great resources. Do feel free to use them. You can access any of these help desks via the link shown on this slide as well. And these are the contact details if you wanted to stay connected with the help desk. So that's a brief introduction on the help desk. Now to move on and talk a bit more about China. We heard yesterday from Juan Carlos Moritz he mentioned the world of China. He spoke briefly about market access and IP and ownership and evolving laws, which are all segue into this particular topic. In Antonio's session this morning, I saw flagged up the interesting case studies and practical tips, and I'm hoping you'll be able to take away some practical tips from this topic today. Faris has given some wonderful practical experiences of what it's really like in China, and we just heard from Alan in China that done the right way, you'll get things done, and that's a great little sentence there. Done the right way, you'll get things done. And again, I'm hoping that you will pick out some of the right way to do things from an IP perspective as we run through this presentation. So if you take China, you can't look at one market in isolation. I think we all understand that goods and information flow quickly from country to country. Much has already been said about the Chinese economy, about software, and about China's green transformation. China's the largest exporter in the world. Its highest value export products include mobile computing devices such as tablets and laptop computers and cell phones and smartphones and computer processors and controllers, liquid crystal display panels, and so forth. China's by far the largest market for electric vehicles. So the first giga battery factory built by Tesla outside the USA was in China. And China needs continued growth to become a medium level country in terms of its GDP per capita. That means that China needs to double its 2020 GDP again to achieve this status by 2035. Huge ambition and big figures. And with a top-down government, China has set out its 14th five-year plan centering around the dual circulation strategy. And this was first articulated by President Xi Jinping in May 2020 as China began its planning of its post-pandemic economic recovery, with growth driven by strong domestic demand and combined with exports based on advanced manufacturing. In fact, Chapter 5 of the plan describes plans for building a digital China with 7 core industries at the forefront, including cloud computing, big data, Internet of Things, industrial internet, blockchain, artificial intelligence, and virtual and augmented reality. And 10 areas where such technologies should be applied, including smart transportation, smart energy, smart manufacturing, smart medicine, and even smart government. So in this context, changes are being made to the intellectual property laws in China, which is leading to a steady upgrading of the intellectual property rights regime. And the two main factors which seem to be driving this change are accession to the various trade agreements, originally the World Trade Organization, trade-related aspects of intellectual property rights, or TRIPS, but more recently the bilateral trade agreements, through which China is aiming, I should say, to enhance growth through trade. And also a recognition in China that innovation is key to increasing value, which is another key component of growth. Innovation can only flourish under effective IPR regime. So I think the point is big developments are the theme here. We've seen a restructuring of the intellectual property registration, management and enforcement government bodies in China, which has been part of a bigger reorganization. This was announced during China's Two Sessions meeting in March 2018, so a couple of years back now. And they have merged together the State Intellectual Property Office and the China Trademark Office under the China National Intellectual Property Administration. That's the CNIPA. And this seems to have been beneficial. You've got greater resources to handle and enforce intellectual property cases. And as registration and enforcement will also be handled by this one overarching bureaucracy. And we've also seen a move towards a more unified institutional approach from the unification of Chinese governing bodies dealing with IPR. There used to be slight differences between the approaches taken by these different departments. These are now coming together. You can see other changes highlighted on this slide, but even more recently, in October last year, the China's National People Congress published the amended patent law, which has just come into force on the 1st of June. And the law introduced major changes with regards to invention and design patents. The protection period for design patents is extended from 10 to 15 years. And one of the reasons is that it would allow China to eventually join the Hague system, which regulates design rights, which requires a minimum protection period of 15 years for design patents. And the amended law allows companies to register partial designs, which is actually a common practice in the EU and in the USA. But partial designs were not recognized in China, where design patents could only be obtained when applied for together with a specific product. The lack of protection for partial designs was particularly problematic for the protection of graphic user interfaces, because enterprises would need to register the design together with the product, for example, in the smartphone industry. So the amended law increased the amount of damages that can be claimed for patent infringement. The statutory damages were increased up to 5 million RMB, and punitive damages added for cases of severe bad faith infringement, forcing the infringer to pay up to 5 times the damage caused. Also on copyright, in November last year, the NPC passed the latest revision to the copyright law, which came into force again on the 1st of June this year. And the amended copyright law contains a provision allowing for the shifting of the burden of proof from the copyright owner to the infringer in case of calculating the damages, with statutory and punitive damages matching the same as the new patent law. The amended copyright law actually moves closer to the open-ended concept of copyright found in many countries with a strong civil law copyright tradition. And the new law adopted a broader open-ended list of copyrightable works as well. So a big changes going on in China. This slide I put in to give you a snapshot of the kind of inquiries that the China Help Desk receives from EU SMEs doing business in or with China. As you can see, the trademark issues tend to be the largest type of issue that's raised with the help desk, but a broad variety of other cases. This is a snapshot taken over the course of just a few months. If we were to extend this during the life of the help desk, it would be a little bit different, but the trademark issues have generally been highest, and patent issues and copyright, and general questions on strategy on intellectual property have tended to form the other major segments. In fact, in June last year, the European Chamber of Commerce in China released the European Business in China Business Confidence Survey. And according to the report, EU companies operating in China claim that they've seen continuous progress on drafting and enforcing intellectual property related regulations in China. So significant improvements have been made in IP protection laws and enforcement over the past decade. That report also said that IP protection has long been among major concerns for EU SMEs operating in China or looking to enter the market. I think that comes as no surprise. And when it comes to the impact of intellectual property rights on research and development, 2/3 of the respondents rated the effectiveness of Chinese IP protection laws and regulations as either excellent or adequate. So that's sort of reassuring. Statistics show that China has seen a marked improvement in both IP legislation and enforcement, which is the highest rate of positive sentiment since 2012. So perceptions are improving as regards China's intellectual property rights. So that kind of sort of sets the scene in a way. I thought now we could take a look at the differences you're going to encounter between the EU and China. So it's important to remember that when you go there, things will be different. And I think that message has come across quite well already from previous speakers. But let's take a look at the differences from an IP perspective. In general, in China, registered intellectual property rights only are protected. You need to register your rights in order to be able to enforce them. I say in general, there are caveats there, but the point is, if you think that if you're going to China, you're not likely to be able to look after your idea, your concept, unless you have registered your intellectual property rights there. Whereas in Europe, you can kind of expect that some unregistered intellectual property rights can be enforced. So I should add specifically a mention on copyright in China. Although under the Berne Convention, which China has acceded to, you do not need to register copyright in any of the Berne Convention countries, including China. Registration is available in China, and it really is advisable to register copyright in China. It's very inexpensive to do, and it means that you will have a much easier task of enforcing your copyright if you ever have to do it. So it's advisable. Chinese courts generally require you to have registered copyright in order to produce it as evidence or some sort of notarized proof of copyright in order to accept your case. So that's well worth bearing in mind. In China, you can only start enforcement procedures once you have formally registered your intellectual property rights and they've been published. Whereas in Europe, you can start enforcement proceedings for your intellectual property rights as soon as you have filed your application. So quite a difference there. Intellectual property rights are territorial, whether you're talking about Europe or China. And what that means is that if you register your rights in Europe, you are not protected in China. You have to register in China. Similarly, if you register in China, you are not protected in Europe. So make sure that when you're registering your rights, whether it's trademark or patent or whatever it is, you specifically register in the countries that you need to cover in China in this particular case. You can extend both patents and trademarks. So if you register in Europe, you can extend them to cover China through various treaties. For example, China is party to the Patent Cooperation Treaty and the Madrid system administered by the World Intellectual Property Organization. These two procedures can simplify extensions of your patent registration and in the case of the Madrid system, your trademark, so that they can be easily registered or more easily registered in China. You can initiate these steps through your local IP office. So that's quite an efficient way to gain cover for China. In terms of registration, invention patents, utility models, and design patents can be registered with the China National Intellectual Property Administration, CNIPA, in China. Trademarks, obviously, at the Trademark Office. I said that the registration of copyright is not compulsory, but in order to get protection, it really can help improving the ownership of copyright in the case of infringement if you register in China and you register your copyright at the China Copyright Protection Center. In the EU, obviously, copyright does not require registration, but you still need to keep a record of authorship and a date of when the work was established in order to enforce your copyrights in Europe. So those are some overall differences. Taking a slightly closer look at the individual rights for trademarks. Let me just give you some sense of the scale in China in terms of registration. Last year in China, 5.7 million trademarks were registered with the CNIPA. That's a huge number. It dwarfs any other region or jurisdiction in the world. It's a huge number to register. During the same year, there were 149,000 trademark opposition cases reviewed, and this was interestingly, this was a nearly 65% increase year on year in terms of reviews of trademark opposition cases in China. So a big increase. And around 358,000 trademark review cases were completed, and that's also represents an increase year on year. Registered Chinese trademarks too on the slide there is something I wanted to emphasize. Although it's not required by law, if you're doing business in China, it really is useful to translate trademarks, trademarks composed of words anyway, into Chinese in order to be better protected, as well as appeal to people that you want to do business with in China. So many may not speak any English or other European language or German or whatever. So they will have to come up with their name for your company, your product, whatever it is that you are looking to market in China. So it's really a good idea to seriously consider translating your word mark into Chinese. There are three common ways to do that. When you're choosing a Chinese trademark name, you can literally translate your name into Chinese, or you can use a transliteration so that you get a word in Chinese that sounds like your word in German or English or whatever. Or you can try to use a combination of these two methods. So the best trademarks are those that sound the same as your mark in the European language, but also make reference to some sort of defining characteristic of the brand, or have some sort of positive meaning in Chinese culture. This is a bit of a minefield, so just be careful if you're doing a direct translation. That can and has had the effect on many brand owners of leading them into a Chinese name that's been, shall we say, not particularly positive. So you do need to take care when doing that. It's advisable to get a language expert to help you. I mentioned the Madrid system just now. So you can get international registration extending to China through the Madrid system. You can do it through that system, or you could register directly with the CNIPA. But here's another caution. Because China divides goods and services into more subclasses than you normally get under our trademark registration system, you need to be careful that the trademark you are registering is really put into the right subclasses in China. So just bear that in mind. There are differences. Get some help or advice from a trademark agent with experience of China in that respect. Otherwise, you may find that your trademark might be in the overall right class for your business, but it may fail to protect you in the subclass that you need to cover, and that can have problematic effects if it's not in the right subclass in China. So there's a difference there. Taking a look at the situation on patents with China versus Europe. Invention patents take, it varies on the complexity of the patent, but typically three to 5 years. They last for 20 years, and this is the same coverage as you get in Europe. Although the time for registering a patent in Europe does tend to vary on the specific EU country that you're registering in. Invention patents made in China need to first apply to the State Intellectual Property Office under the CNIPA for a confidentiality examination if you're planning to make the first application outside of China. So just bear that in mind. Otherwise, if you don't do that for a patent invented in China, then you may not be able to obtain a valid patent for China. So bear in mind that situation as well. Utility models in China. Utility models are for new technical solutions which involve a specific shape or structure of a product, which are fit for some sort of practical use. Utility models are like a lesser patent, and they are granted faster, and they require no substantive examination. So you can typically get a utility model granted within 1 year, in less than in 12 months. Utility models are much less common in Europe. Not all EU countries offer this form of protection. You get the Patent Convention Treaty filing route available in China, so you can obtain rights in China by filing your application directly with the CNIPA patent office, or you can use the Patent Cooperation Treaty filing route. The PCT route gives you an additional 18 months to consider the viability of your invention in China. So it kind of gives you that bonus time to assess whether this, what is typically a big investment, is viable for China. The PCT route is not available for Taiwan or for Macau. So there are differences. If you're aiming to have your patent registered there, you have to adopt a different process. I wanted to go into the utility model situation in China in a little more detail, because it's quite a big issue for European countries. So, and this is Article 9 of the Chinese patent law. which basically sets out that you can apply for both types of patent, an invention patent and a utility model patent, at the same time. And the benefit of that is that you can have a utility patent granted very quickly, and that activates a level of protection for you, whereas an invention patent can take 3 to 5 years. And if you're successful in getting your invention patent, you can then waive the utility model patent, allowing you to keep the invention patent. So in this way, you get the benefit of as I say, the early granting of the utility model patent, and then you can build upon that the long-term protection for the invention patent. In last year, the CNIPA granted 530,000 invention patents, and this brings the total number of patents granted in mainland China to 2.2 million. And the number of invention patents per 10,000 people in China reached just under 16, which kind of exceeded the targets that China set out in its 13th 5-year plan. We're now into the 14th 5-year plan. And in last year, there were 2.3 million utility model patents and just over 730,000 design patents authorized in mainland China as well. So utility models, a lesser patent available in China, quicker to be granted, no substantive examination, and therefore cheaper to apply for. So well worth considering. So just taking a look at the other rights that can be compared between China and the EU. So in China, you don't have any unregistered design protection, whereas in the European system gives you the option to have your design protected for 3 years from the date it was first made available to the public within the EU. Without the need to have it registered. In China, you need to register your design, and under the amended patent law, it's protected for 15 years. Whereas in Europe, registered designs can be protected for 25 years within the whole of the European Union, or within the state where it was registered either. In terms of copyright, copyright is protected from the date of creation, but in China it's best, as I mentioned, to register your copyright to make sure that you can make use of it if you ever need to enforce your right. By and large in the EU, you do not need or you cannot register your copyright per se, but you need to keep proof of your copyright, so that you should keep a record of the authorship and date that the work was created in order to enforce those rights. In China, databases can be protected as compilation works. So to qualify as a compilation work, the work should be a collection of data and be arranged in a way that adds some sort of value to the data, such as through the selection or the arrangement of the data, or the originality in the presentation of the data. And in Europe, databases can be protected through copyright if they are original intellectual creations, and this gives the copyright holder the right to reproduce, adapt, and distribute the database or any variation of it. The protection is actually applied to the structure of the database and not its content per se. So just taking a look now at the enforcement situation, hopefully you won't need to go into this from your business perspective, but nevertheless, it's important to note there are differences. In China, a big difference is that generally the intellectual property right owner carries the burden of proof. In other words, that means it's your responsibility as the owner of the IP to collect the evidence that has to be presented in court in the majority of cases. Also, there are quite onerous steps that EU SMEs have to go through in order to have their evidence accepted by court. So evidence must be notarized by a Chinese notary public, otherwise it won't be accepted. There are one or two exceptions now creeping into Chinese laws. For example, under the revised trademark law, in certain circumstances, the infringer can be ordered to provide some evidence to the court. But by and large, expected you have to jump through a number of hoops in order to get your evidence accepted in the court. Whereas in Europe, courts can actually order infringers to provide relevant information and evidence to the court. So in the EU, courts can help the IP owner collect evidence. In China, the court determines a time limit for producing evidence in the pre-trial preparation phase. This can be negotiated by the parties and needs to be approved by the court. And then all documents have to be submitted in Chinese and must have notary confirmations as well. So that's quite a big difference. Finally, just quickly on these last 2 points, administrative actions in China, major difference between China and EU, and a positive one. China has many, many more resources available to you, the IP owner, to help you take administrative action. There's not strictly anything directly comparable in the EU. So through administrative action, you can go and file a complaint to the administrative bodies, who can then take action on your behalf to put a stop to some sort of infringement of your product or your brands. There are limitations with administrative action. Expect it to be useful in simple and straightforward matters. Don't expect the administrative authorities to assist with complex issues like which require expertise, like patent infringement cases, where you really need patent experts to deal with the issue, and that goes to court. And also there's the possibility of dealing with copyright cases now via online courts. And there are internet courts in China which have jurisdiction in online copyright infringement cases. And these are usually faster, more efficient, and therefore a lot less costly in handling these kinds of cases. So these courts can handle the whole case from lawsuit filing to the verdict announcement online, saving obviously travel costs and time. So I'll actually now take that theme up a little bit more. And I wanted to talk to you about a sort of cutting edge area and technology area, which will affect IP issues in China. This was a particular case that came to the China Help Desk that we dealt with. It involved a Polish photographer who set up a business. He went to Hangzhou to study the Chinese language and was an avid travel photographer and took many thousands of photographs during his stay, and capturing mainly the daily life of Chinese people, architecture and landscapes and so forth. And he exhibited quite a lot of his work in exhibitions, in a couple of exhibitions in China, and licensed some of his photographs to magazines and travel agents. And this motivated him to open up a photography studio back in Poland, where he came from, and then to establish a branch in Hangzhou. And he was able to get contracts both in the EU and in China. But in 2018, so a couple of years back, he discovered a new method of intellectual property rights protection, the use of blockchain. He found that some private companies in China can provide the service of including any information, for example, a photograph, in a blockchain. And this is really a more affordable way to register copyright than voluntary copyright registration, because it can be done for every image. It provides a timestamp proving when the picture was taken. And a blockchain effectively allows the recording of all the metadata for each picture, such as the camera model, the white balance, the ISO, the aperture, shutter speed, photo editing software used, a whole host of information. So he adopted this process as part of his regular IPR protection mechanism for his published and unpublished works. And then in 2019, he discovered that a Chinese photographer from Beijing was presenting his work as her own, and had developed a full website using pictures from his portfolio while offering similar services. So he was not in a position to afford any sort of long judicial copyright dispute with the infringer, and looked for some sort of alternative dispute resolution methods to try and negotiate and send cease and desist letters, but these efforts were basically ignored. So his Chinese lawyer recommended filing a case in the Hangzhou Internet Court. And internet courts have jurisdiction in online copyright infringement cases, as I've mentioned, and they're usually faster and more efficient in solving this kind of case. So the case was presented to the Hangzhou Internet Court. The blockchain protected evidence of copyright was presented alongside the blockchain record of the Chinese photographer's website, and the entire judicial dispute took just 1 month, and all the proceedings were online, where the lawyer uploaded the description of the facts and all the evidence. There was a brief hearing that was conducted online, where both parties explained their position, and the whole hearing lasted 28 minutes. And the Polish photographer didn't need to travel further, so that saved costs. And a few days after the hearing, the judgment was presented by the court, and the court ruled in favour of the Polish photographer, and the Internet Court had accepted the blockchain as evidence and reached a conclusion that there was a copyright infringement. So I think the lessons from that are blockchain technology can be used to record online evidence, which is kind of relevant in today's world. And blockchain technology can be an alternative way to prove copyright in the case of published and unpublished works. It provides timestamp, and internet courts in China are already accepting this as evidence. And lastly, internet courts in China are an efficient way to solve online copyright disputes and infringements. So quite an interesting case, and worth thinking about if you have copyright to protect. I'm conscious that time is ticking on, so I'm going to move quickly through the next couple of slides. In fact, yes, I'll deal with this very briefly. This slide was speaking to artificial intelligence. So I just wanted to mention that for artificial intelligence, copyright in China only protects expression of the algorithm, not the core idea that of that algorithm. To protect the core idea of that algorithm, you have to use patents. There is a trade secret law, which can also be used to protect data as well as algorithms. And if information within the data is not known to the public and has some sort of commercial value, and you've taken some sort of confidentiality measures, then it can be protected as trade secret. But just be aware that there are complications for machine learning in artificial intelligence, where you use algorithms and data. The machine learning extracts information from a variety of sources in the public domain, so it does not become confidential because it's used in the machine learning. So that affects whether you can protect or not using trade secrets. So just be aware there are some complications around that. Similarly, if open source code or disclosed third-party codes have to be referenced in the development of artificial intelligence, one solution would be that at the beginning of the project, the rights holder needs to differentiate between the open source part and the self-developed part. And this would allow the rights owner to make the original source distinct from the self-developed part, and therefore claim some sort of confidentiality of the IP that's been developed. I've spoken about blockchain technology. which is really the best known behind the technology behind cryptocurrencies like Bitcoin. And that's basically, for those of you who don't know, it's an open ledger of information that can be used to record and track transactions. So I'll not go into any more detail on that for the moment. We're into the last, I think, 2 or 3 slides now. So just to mention that IP is an issue that you're going to come across in a connected world. And as soon as you set foot internationally, and particularly step into China to do business, there are issues that you really need to consider. You have to consider protecting your intellectual property while dealing with, as we've heard, contractors, partners, regulatory authorities, and many other parties as well. And that is a constant challenge. So in addition to patents, which is the source of many businesses' competitive advantage, know-how, trade secrets, and confidential information may also need to be protected. And non-disclosure agreements, or as we heard from FIRUS, NNN agreements, should really be used in your business dealings with third parties, whether big or small, and in China or in any other international business destination. So let's talk a little bit briefly about non-disclosure agreements. This is a wonderful way, because you should, as a best practice, you should have agreements in place with people you do business with. So it is only a small step to add in clauses dealing with IP protection and establishing your protection. Very, very cost-effective way to enhance your intellectual property rights, and well worth doing so. These are some of the issues on this slide. I'm happy for these slides to be shared after the presentation to people who attend. So maybe I can just leave these points at that for the moment, and just a few. These are just a few pointers on some of the topics that you need to think about when you include IP provisions in your non-disclosure agreements. Oh, but I should mention one particular issue, and that's the issue relating to China's copyright law. China's copyright law recognizes contractual terms for determining ownership of new intellectual property rights that are generated or derived from licensed rights. This is very important. You need to address ownership issues in license agreements. Just be aware that commissioned intellectual property belongs to the commissioned party, unless the contract states that the commissioning party owns the intellectual property. So it's important that your contract states clearly what intellectual property is to be developed and who will own it. Improvements are generally owned by the party that makes them, and cannot be automatically granted back to the other party without some sort of compensation or some sort of reciprocation, such as granting a license to the other party's improvements. And also the Chinese party cannot be restricted from making improvements to transferred technology. That's another issue to be aware of, and using those improvements. So any such restrictions will be unenforceable. So just be aware of these points when you're considering licensing and tech transfer. These are topics that really would demand a separate session in their own right. So just be aware that I'm only skirting over them in the very briefest possible way. But really come back to us if you're considering licensing or tech transfer. And think too about the way that you are setting up your business partnership in China. You know, the safest way to do business in China is really to follow an EU customer into China. That's probably the safest way. So if you're an SME and you're supplying a major automotive manufacturer or some such, and they ask you to supply them in China. That's certainly probably one of the safest routes into the country to do business there. Otherwise, a non-exclusive distributor agreement would be relatively safe, and doing business via e-commerce with China also. Going into a wholly owned foreign enterprise set up in China, or licensing somebody in China with your IP, these are riskier steps to take. And the joint going into a joint venture with a Chinese partner is probably the riskiest way to enter into a business partnership in China, because there's always the danger, and it does happen, that your know-how, your innovations, your intellectual property leaks through to the various other partners to the joint venture who are outside the scope of your joint venture agreement. So a lot of caution to be exercised there. So do be careful. We heard reference to finding the right partner and how important that is. Again, these are just a couple of concepts that you should really have in your mind when you're looking to deal with a partner in China. And because we're running so over time, I'm not going to explain them anymore. But I'm going to move on to the last slide, which is basically that you need to do your due diligence in China. I guess what I really want to sum up by saying is that while you're looking at this slide, and these are really key takeaway points, I hope, you need to make a deliberate, not an opportunistic decision to go to China as part of your internationalization. Make it deliberate and planned. Don't assume the law is the same as in your home market. I hope you've seen that from the slides. IP registration is pretty much everything. So do it early and do it as broadly as you can in China as well. And make sure all your rights are in your own name. I know it's been said that a local partner can help doing certain aspects of business. From my perspective, I would not recommend any rights in the name of your local partner. You should make sure that all your intellectual property rights are in your own name in China. If the people you're doing business with in China don't actually need to know, then if you follow the mantra of, well, don't tell them if they don't need to know, that'll probably help you reduce the chance of your innovative ideas sort of leaking in an uncontrolled way. And lastly, I guess, is contact the China Help Desk for further advice. You don't need to be an expert on any of these IP issues. You're an expert in your business, but know that there are these issues to deal with. And so, if you need to find experts to help you, a good place to start will be the China Help Desk, and then you can go on and we can sort of point you in the right direction. And you'll certainly need to work with other experts, lawyers, trademark agents, patent agents, and so forth. We're not here to replace them. We're just here to sort of steer you in the right direction in the first place, I think. So sorry, that's been a bit rushed towards the end. I'm trying to sort of keep vaguely within the allotted time. But this is the helpline for the help desk, and do feel free to reach out to us and send your questions to us after the event too at any time in the coming days and weeks. So I hope that was helpful.
Thanks a lot, Simon. Thanks a lot for breaking down this broad topic to the key aspects. Thanks a lot.
Mm-hmm. Yeah, it's usually, we all know it's commonly quite a dry topic, everything related to law. Talking about like science-based startups, they find some other topics interesting, which you might not find interesting, like engineering, numbers. So, but I think it was good, was well prepared, and I think it's also extremely important to at least have heard about it, get this understanding. And I think I'm very happy that there's someone out there in the European Union who can help me addressing some questions, and without going through the procedure of hiring immediately some kind of a lawyer, which usually comes up with quite a invoice, So very happy about your support. I think.
Yes, I'd like to invite one of our participants who's in the audience today. It's Martin Bothe. He's the co-founder of Smarterials, a medtech company. They produce medical gloves. And Martin, would you be so kind to share the experience you made with Chinese partners? I think it was concerning an NDA. Please share your experience and address your questions.
Sure. First, thanks, Simon, for that in-depth information on IP rights, because that was really a point we were thinking a lot about quite in the last few years, and so also good to know whom to approach in case we have questions there. So I notified your address there. Let me quickly run through what we've experienced. I'm picking up where you left, on the last slides. We're working on a new generation of medical gloves. We have applied for patent via PCT also in China. So it's still pending there. It's granted elsewhere. And so there is a potential partner in China. We think about licensing our technology, but we already had big problems getting a proper NDA in place, like the terms you mentioned. We wanted to have it as we usually do it, but they drilled in where they could. They wanted to take out the company holding, but just put in the subsidiaries of it, and also they wanted to take out employees of that NDA, because they said they cannot guarantee for their employees, and we had to fight about the law. So we really wanted to have German law, in any case, any European law, but not Chinese law, and finally we really got to that point to have an NDA in place there. But then they said, well, okay, now we want to have a cooperation agreement. And then the whole dance started from the beginning. And okay, there was the point where we said, okay, no, we are not going to rediscuss all those points and start from scratch again on the same topics. So well, we're still in contact there, but it's not really moving on. And this is, well, disappointing, because on the other hand, there are lots of interesting points in approaching that big market, and also these huge investment volumes and productivity in China. So do you have any idea how to move on in such a case?
Yeah, interesting. Thanks, Martin. Yes, I mean, I picked up a couple of things there. First, in terms of the law to use for a non-disclosure agreement, be very careful with requiring the jurisdiction to be Germany, because you really need your contract to be enforceable in China. So if you have it enforceable in Germany, then courts in China will react that it's outside their jurisdiction to enforce that agreement in China. And we'll leave it to you to try and take action in Germany. So you actually need to make sure that the NDA is enforceable under Chinese law. Uh-huh. So you're protected there. Okay. So that's one thing. If they are, certainly if they're prevaricating about signing on behalf of employees and holding companies and so forth, and don't want to sort of include them under the requirements of the agreement, then that's most certainly a worry. You have to ask, although they may have given a reason for the employees, why would their holding company not be a party to the agreement, and who else apart from them could be responsible for safeguarding your intellectual property rights within their employee infrastructure other than them? So, these are questionable reasons to fight back against terms of the contract that you put in. I think the key, my suggestion, you may have done this already, but I would certainly, if you're going to China, try to do so from strong foundations. That means having some rights already registered in China, even as you consider, or before you consider talking to possible partners there, because
it is. I mean, it is registered. It's not granted, right?
Oh, you filed already. So okay,
Yeah.
well, well, that's great. I mean, you could if you're simply applying for a patent registration, is there anything else that you need to consider as well? Do you need to protect the name of your company, or do you have any instruction manuals or other material or advertising? Yeah, that may be a copyright issue. So you may actually need a slightly broader spectrum. It need not cost much at all. Your biggest investment is through the invention patent registration that you are extending to China. That's a big investment. Other rights are, there's no reason not to register them from a cost point of view because they are inexpensive. So I would look at what a broader scope of rights to protect your know-how, your business interests in general might be available to you for China, and that gives you a position of strength. Once obviously with the patent, I mean, it sounds as though it's likely you will be granted the patent if it's already granted in the EU, but it's not a given. So hopefully it will be granted. But just bear in mind the companies you're talking to may have a slightly different approach to a patent which has been applied for compared with one which has been granted in terms of how they negotiate on agreement. So that might be a factor. But nevertheless, China is a first to file jurisdiction. So once you've put in your application, then nobody can try and overtake you in China and try and get in and try and take your place in the queue, as it were. So you are in a relatively strong position once you've started the application process.
So enforcement is as you said, these processes are becoming better and better in China, because that's what I somehow understood also from the most discussions, but I was not able to judge how trustworthy the statements of our Chinese partners are there on that side. So good to have confirmation from your side.
Yeah, they really are. I mean, there's a lot of support there and a lot of emphasis on supporting IP owners' rights in China. It's just that you have to do it the Chinese way. There's little interest or scope in supporting foreign businesses in terms of their foreign rights. You have to have your rights in China in place, and then you can get a lot of help and you can get things done.
Okay, cool.
All right. I think we are slightly over the time, but thank you also for the question and the answers. I mean, that's why we set up this event and this live session, where we can actually address it immediately. So I think I would like to wrap up this morning, and thank you so much, Simon, for your presentation on IP. Very interesting, broad topic. We will take care that your slides are shared afterwards. So for the audience, you can just have a look at it in detail and read the points, because we somehow rushed a bit. I know you probably could continue talking for another hour, as there's such a broad topic. Yeah. All right, Simon. Then thank you so much for your time. Yeah. And we will now go into our lunch break.